I wanted to introduce to you this incredible magical hat. I call it the magic court hat. And this is the rationalization that schools use whenever they want to, investigate and punish, people accused of rape. And so you may have heard, whenever people advocate for the due process rights of students, that those who support the current system in place will say, well, it's not a legal proceeding, it's not a court of law, it's not a criminal trial. Therefore, students don't need, the level of protections that, those in those trials have, those in those situations have. Of course, no one's advocating for those exact level of proceedings. But on the other hand, when they want to act like a court of law, they'll say, well, we have an obligation to make campuses safe. There's an epidemic of crime, and we have to address that epidemic of crime. And we must encourage reporting of offenses at all costs, even if that cuts into the due process rights of the accused.
Ladies and gentlemen, our next speaker has spent years concocting conspiracy theories about how men and boys are discriminated against in education. Do not let his seemingly innocent face fool you. This man has a misogynistic streak a mile wide and merely hides his true agenda to make educating girls illegal behind a preposterous ruse of compassion and concern for men and boys. So here to push his latest myths, that some men accused of sexual assault on campus might not have done it, and that due process actually exists for a reason, I give you Jonathan Taylor.
Can you hear me okay? Yes. All right, good. Well, thanks everyone for having me. Thanks to the Honey Badgers for setting this up and for having me here. Very excited to be here. So my name is Jonathan Taylor. I'm the founder of Title IX for All. I've been working on education issues since about 2009. Originally, I focused more on educational achievement issues, but especially in the last 4 or 5 years, I started to really focus on misconduct issues, due process issues for students who are accused of what are called Title IX related offenses. That would be things like, sexual misconduct, dating violence, stalking, sexual exploitation, and other types of offenses for which young men are being accused and expelled at quite an alarming rate from higher education. So nowadays I run this platform with my wife, who unfortunately could not be here today. Her name is ICMI Taylor, and I'm very happy for her assistance. Without her assistance, I could not be doing the level of work. We could not be doing the level of work that we're doing now. So I'm very, very grateful for that. And that's just the front page of our website right there. A lot of our work that we do recently is really focused on the legal arena. There have been, as you've probably heard, many lawsuits filed against higher ed institutions. We track those in a database that we have created from scratch. There's now roughly 1,000 lawsuits that we've been tracking, and we not only track those lawsuits, we include tons of legal files. By the end of the year, we're on track to hit roughly 100,000 pages of legal files, which is a big milestone for us that people can download and read, examine. So naturally, this would be a good resource for attorneys who are litigating these cases. Several attorneys have emailed me saying, thank you so much for this. It helped me file my first Title IX lawsuit against a university. And of course, it helps many parents and many students who are just trying to find out their legal options, trying to find out if there's an attorney who has a lot of experience. Because of course, every attorney will tell you that they're great, but here you can actually go in and look at their track record and see how they do. So. This is just an example of our search engine where you can search for all the types of lawsuits that we track. You can search them by state, by when they're filed, by which judicial circuit, by which attorneys have litigated which cases, things like that, by which claims are brought, whether it's like a Title IX claim or a due process claim, things like that. And it can get very granular with the way you may want to search and sort each segment of data. So again, this is really good for attorneys and legal analysts and reporters and things like that.
Hey you! Yes, you! Watching this video. Did you miss out on going to the International Conference on Men's Issues? Or did you go and now you missed the fun times you had at this amazing event? Experience the magic of ICMI 2019 again, or for the very first time, with Honey Badger Radio's ICMI disc set. The disc set brings ICMI presentations together in one convenient package, as well as disc set exclusive Badger bonus content. Enjoy behind-the-scenes Badger interviews with free speech and men's issues luminaries, like Sargon, Janice Fiamengo, and Count Dankula, as well as a never-before-seen Badger cartoon. Also available is sparkling ICMI merch, such as our professionally designed program book, sticker sets, badges, and more. Go to feedthebadger.com and claim a piece of men's rights history for yourself.
I want to talk briefly about the roots of the conflict. One of the first, the conflict between due process and survivors' rights, accusers' rights, if you will. One of them is there's been, as you've probably heard, an unchallenged, decades-long narrative that there's an epidemic of rape on campus. A lot of this is backed up by studies which have very, very flexible, shall we say, definitions of sexual misconduct. That don't quite mirror the legal definitions of sexual misconduct. If you look at the studies that are done by advocates and the studies that are done by like, say, the Department of Justice. The Department of Justice study is wildly at odds with the studies done by campus activists. The second is there's been a tradition of deference by the courts. Courts have tended to kind of let higher education officials do their own thing, so long as they stay in their own lane. So long as the decision that they're rendering about whether to remove a student from school is a genuinely academic type of decision, they've generally kind of looked the other way and let schools do their own thing. But now they're obviously not making decisions about academic matters in these cases, so that is changing. There's also in our culture just a general, I'd say, desire to see male offenders punished or just held responsible. Many of you may have heard the phrase equal pay for equal work. Equal time for equal crime is another concept that has not really caught on in our society, and of course, as a consequence, men are 93% of those in our prison system. The notion of trickle-down privilege, that somehow the privilege just trickles down from the top, somehow it just didn't make its way to these guys in our society or in prison. And of course, almost no women who are who are falsely accusing people of rape are charged for their crimes either. So. There's also a sort of a changing of the scope of what the mission of higher education should be. When you think about what higher ed should be, you would think that it would be about academics. Well, nowadays, education, it's really kind of like an education resort, where administrators are increasingly involving themselves in tons of social activities by students, and they sell their universities, their enrollment basically, on the notion of these great social activities. So there's and of course, the more you need that, the more you'll have more administrators, and that links to another bullet down below. There's been more and more what we call administrative bloat, just the incredible increase of administrators in higher education. In the last 25 years, the number of higher ed administrators has doubled. So you now have just tons of busybodies that are just looking for work to do. Lastly, there's been the dominance of the feminist narrative in higher education, which is, that men are privileged. You look at the top of society, take an inventory of the people there, and then based on that, you presume that all members of that class are privileged, and that's a fallacy called the apex fallacy, but it's also central to feminist ideology. And then last but not least is the culmination of all of this, is the Dear Colleague letter issued in 2011 by the Department of Education. This basically mandated that all schools would have to investigate every single sexual assault accusation that came their way. They would have to do so by a low standard of evidence, There was no regard really to the due process rights of the accused, and now we are seeing the results of this. So for those of you who don't know, this is kind of the flow of a Title IX proceeding or a grievance process. When an accuser, a female student in almost all cases, she'll make the initial complaint. There'll be a preliminary investigation. Then there should be some notice given to the student who is accused. And then there's usually some kind of interim measures. For example, the school may institute a no contact order saying the male student cannot contact the female student. Usually they'll make this mutual, but sometimes not. So the female student can, in some cases, attempt to contact the male student, and if he responds, well, he's violated the no contact order. Sometimes they'll go ahead and issue just an interim suspension, so the guy can't even set foot on campus, and things like that. So then there's the investigation. Usually someone prepares an investigative report or an investigative summary, and then usually a panel of people. It could be administrators, could be a combination of administrators, faculty, and or students would then decide the young man's fate. And very often these panels are stacked with sex assault victim advocates, Title IX related professionals who really came up through their own ranks by advocating for women exclusively, and after that, there's a decision by the panel, or sometimes there'll just be a decision by one person. And then after the decision, there is a potential appeal if the school allows it. Now, I wanted to introduce to you this incredible magical hat. I call it the magic court hat. And this is the rationalization that schools use whenever they want to investigate and punish people accused of rape. And so you may have heard, whenever people advocate for the due process rights of students, that those who support the current system in place will say, well, it's not a legal proceeding, it's not a court of law, it's not a criminal trial. Therefore, students don't need the level of protections that those in those trials have, those in those situations have. Of course, no one's advocating for those exact level of proceedings. But on the other hand, when they want to act like a court of law, they'll say, well, we have an obligation to make campuses safe. There's an epidemic of crime, and we have to address that epidemic of crime. And we must encourage reporting of offenses at all costs, even if that cuts into the due process rights of the accused. And so they try to play both sides of this issue, but it doesn't really work. I'll give you an example. So when they say, now we're not like a court of law, they say, well, they'll prosecute all charges, no matter how baseless. So, in a normal, criminal justice setting, you throw out baseless accusations. You say, well, you can't, you're probably not going to have much success with that type of charge based on the evidence. So they just decline to press charges. The definitions of the crime, as we've noted, are more flexible in student conduct proceedings. They don't have to be the exact same as the criminal code. In many of these hearings, the student's attorney, if he has one, cannot speak, cannot address anything to the panel, to anyone. They're only allowed to whisper in the accused student's ear. It's an inquisitorial system, and it's not really an adversarial type of system. And there's hearsay, so the accuser can say, well, my friend of my friend of my friend of my drug dealer's college cousin, roommate, whatever, supposedly heard this, that the accused student was guilty, therefore he is, and that would be permissible in this type of setting. The school can and often does pick and choose which witnesses they want to hear. They may hear only from the female, the accuser's witnesses, and not the males. And of course, cross-examination of the accuser is forbidden. And if the accuser decides to just not show up for the hearing, then they'll just continue prosecuting effectively anyway. Whereas if you no-showed in an actual court of law, that could adversely affect your case. So this is when they decide that they are like a court of law. Now all of a sudden they are, whenever they want to investigate and adjudicate felony offenses. You would figure that rape is not misconduct. It's a felony. It needs to be treated like a felony. So you would think that this is really in the purview of the criminal justice system. The prosecutor is the institution. not the accuser, just like, in criminal trials, the prosecution is effectively the state. University attorneys can take part in the proceedings. So the accuser's attorney, or the attorney of the accused cannot take part in the proceedings, but the attorneys for the school can. So that's, that's how they work. The accused must raise timely objections. This is something that some schools have gone into a court of law after they've been sued. And then, for example, there was one case called like Jacobson versus Blaze out of New York, where the accused student had presented questions to the panel for the panel to ask of his accuser. And the panel did not ask the questions that he wanted to ask of the accuser, which would have exposed John Doe believes that the accuser was lying. So the panel didn't ask the questions, and he couldn't remember all of the questions that he wanted them to ask. So then he brought this up whenever he sued the university later on. And then the university's defense in the court of law was, well, that 20-year-old student should have had the legal wisdom to raise timely objections, or perhaps even if he didn't know to raise an objection, to raise an exception to address his timely objection that was refused. So for attorneys to walk into a court of law demanding that this 20-year-old kid basically should have the knowledge and wisdom of an attorney and to be able to effectively combat these university administrators who may have attorneys on staff on the panel there in the hearing, that just doesn't make sense. And that's totally at odds with the rhetoric of, oh, we're not a court of law, we don't want to be like a court of law, this kind of thing. And of course, if the accused student is no-shows, he's often presumptively found guilty. And that is like in a court of law. If the accused party does not show up, the prosecution would create a motion for default judgment against the accused, and if the judge thinks that it's a good idea, they'll go ahead and rule in the prosecution's favor. But not so here. If you're so here, if the accused student doesn't show up, he's presumed guilty. If the accuser does not show up, then that does not adversely affect her case. I want to give some examples of abuse. I'm going to go through these pretty quickly because there's a ton. Upon being sued, the school destroys the records of the investigation so that the court cannot look into what they're doing. That was Doe versus Quinnipiac University. There's the next one, the student. There's been several cases where students commit suicide after being wrongly found, guilty by the school administration. One of them, Clocky versus UT Arlington, really doesn't get enough airtime because I believe in this case the person who brought the claim against the university was in fact the father of the accused student, and the father actually appealed this twice to the Fifth Circuit Appellate Court. And then not only did he lose his case both times, but he was forced to pay attorney's fees for the university. So he lost not only his son, but he had a devastating financial loss in that. Another one is the accuser is not a student, but the school punishes the accused student anyway. That's Palo versus Iowa Board of Regents. The accused person is not a student, but the school finds him guilty even though he's not attending the university. Now you might think, what's so bad if this university way over there decides that this accused student is guilty. Well, in essence, if they just keep to themselves, that's not so bad a thing, although it kind of is, but this school actually went out and shared their findings of guilt with as many other institutions as they could. And many of these other institutions will not allow you to enroll unless your existing record shows that you were in good standing. So they effectively went out to destroy this student's access to higher education. Another example, whenever their schools are making their credibility determinations, they may find the accuser more credible whenever she corrects herself, but the accused student less credible whenever he corrects himself. That's Doe versus Loyola University, Chicago. In Romer versus Washington State University, the student was not clearly ID'd. This was a case where she didn't even see the accuser, but she thought it might have been the guy based on some other circumstantial evidence and reports. And the school didn't even know for sure, but based on their system, they thought they did. So. The female student asks for sex in writing. The male student is still punished in Doe versus Occidental. This is one where she texts him. The student is suspended before the investigation, losing his housing, graduation, etc. In other cases, the student is expelled without any kind of hearing or any kind. And I listed Caldwell versus Parker, but there's a more famous case called Doe versus Baum, which is an appellate ruling in the Sixth Circuit, which really addresses this. This next one, Burmeister versus Ainsley Carey et al. This is where the alleged victim is not the accuser, and she denies she's a victim, and she's threatened by the school for defending the accused. This is one where a California school had received a report from a hearsay report, like third-degree hearsay, that he saw Matthew Burmeister roughhousing what he calls dating, what the complainant called dating violence, but it just happened to be both Matthew Burmeister and his girlfriend said that they were just horsing around, roughhousing or whatever. But the school decided to just go ahead and investigate and prosecute anyway. And when his girlfriend decided to speak up in his behalf, the school actually threatened her with punishing her for getting in the middle of their investigation. So. An immigrant studying on a student visa. He was found guilty, and since he's here on a visa, he was deported to his homeland. That's Doe versus Pennsylvania State University. As it just turns out, this student was a Syrian student, and some of you may be familiar that back in 2017 there was a little bit of a military engagement going on in Syria. This student was forced to go back to his war-torn homeland in Syria. There's a case in Doe versus Amherst where both parties are drunk, but only the male student is punished because the female student is incapacitated. This next one is this is kind of an interesting one where the male student is drunk and the female student is sober. Now in this case, they changed, the male student changed from vaginal to anal intercourse in the middle of in the middle of the event, and the female student did not like this. And whenever the male student complained that under the student conduct code, she would have actually been raping him before then because he was totally drunk and wasted, and she was not. The female student made the claim that it was, and the accused male student even said that he was too drunk to remember what had happened, and that was a lot of his defense. And the female said that it doesn't matter whether he was too drunk to remember, he should have known, and the school agreed and expelled him. Next one is where the school decides to change the definition of sexual misconduct in the middle of the investigation of the accused student and find the student guilty based on this. This is a recent case, Doe versus Carleton College, where they decided that the new definition of sexual assault included cases where if the male student cajoles or persuades the female student, then that invalidates her consent, and therefore, he's committed sexual assault. This next one is mind-boggling. There are several cases where the student is not found guilty. They're not found guilty at all. But before the outcome of the investigation and the hearing, the school had put a hold on his transcript, so he couldn't graduate. He couldn't go to another school and transfer credits if he wanted to graduate somewhere else. There was a no-contact order, and of course, there's a mark on his record that there's an investigation. So the school finds him not guilty, but they don't clear his record. They don't lift the no-contact order. They don't lift the interim suspension. And you might figure, oh, this is just a clerical error, right? Well, no, actually, because you learn that for sure when the school decides to fight these guys in court for 11 straight months and forcing them to pay attorney's fees just so that they can clear the record of something that they weren't even found guilty of by the school. It's kind of amazing that I can think of no other motive other than just belligerence and malevolence by university administrators. This next one's very common. Schools may pick and choose which witnesses they want to hear. Another one is the schools will change the date of the hearing if they learn that there's a parallel criminal case, and they can kind of game that to the system. There was one of the Title IX investigators at this school, Appalachian State University, believed that the accused student was actually innocent, and she was going to make a statement at the criminal trial. But the school didn't want that evidence to be in play, so they went ahead and moved up the hearing, which was previously scheduled after this criminal court event, to before, and to prevent her evidence from being in circulation, and then found him guilty and then expelled him. In Blaler versus College of the Holy Cross, one of the panelists who decided the accused student's guilt was friends with the accuser. This was brought up before the resolution of the investigation, and the school, this was objected to, and the school refused to replace him. And the next one, the fraternity support of the accused student is characterized as plotting in Doe versus Rollins College, but if the sorority sisters support the accuser, then that is characterized as supporting by the school's administration. I'm going to skip over this for time. So how many students have been punished? Brett Sokolow is the CEO of INCRM, the National Center for Higher Education Risk Management. It's a legal and consulting firm. He estimates that somewhere around 20,000 since 2011 have been punished. And of course, that's an approximation. There have been roughly 600 lawsuits that have been filed since that time. So that would put the rate at roughly 1 in 40 students who are punished have filed lawsuits, if the number is indeed 20,000. And that number does seem roughly accurate, honestly. Another organization called FACE has claimed that over 1,500 families have sought their help since their founding. That's in 2014. Take from that what you will. When plaintiffs are filing a claim against these universities, what are they really demanding? They're demanding overall a process that is centered on truth. And really, I'd like to say something about truth and justice. Truth is really the centerpiece of justice. You have to have a process centered on truth, because if you don't have truth, then you don't have justice. Any process that disregards truth will inevitably disregard justice as well. So things like meaningful notice. You have to give the accused student notice ahead of a lot of the proceedings. You can't just ambush them without giving them some sense of the actual charges they're accused of or the evidence being presented against them. Meaningful opportunity to be heard. A lot of students will say that they didn't really have a chance to address the evidence in the hearing, and a lot of the time this comes from them not being allowed to read the investigative report, so they can't even see the extent of the evidence that was presented against them. We don't want any conflicts among decision makers. People who are to decide the student's guilt should not have a conflict of interest. And that's the same with the next bullet as well. Reasonable weighting and interpretations of evidence is another important thing. So if there's video evidence that exonerates, that is exculpatory for the accused, that should matter more than, third or fourth or fifth degree hearsay. That's some, if a school is clinging to the latter to kind of override the former, then it's clear that the school is not really concerned with the impact of the evidence. Equal standards, if the student conduct code applies to male students, it should apply to female students, and also an appropriate standard of evidence. It's interesting to see what plaintiffs are not demanding as well. The exact procedures of the criminal justice system, and this is something that is just brought up anytime supporters of the current system object to the current system. People will say, well, it's not a criminal trial. Well, no one is demanding the procedures of a criminal trial. No one is demanding, sworn statements by the accuser with the threat of, punishment for perjury. Schools don't have the power, subpoena powers, and of course, no one's demanding, a beyond a reasonable doubt standard as well. It's also interesting that people generally are not demanding that schools punish false accusers. Although, reasonably, I would think if they're in this business, then maybe they should, maybe it should go both ways. And the last thing that people are not claiming in their lawsuits, and this is, again, something that, maybe they should, is that higher ed should forgo entirely the role of investigating and adjudicating crimes. Investigating, I can kind of see that if their purpose is to funnel things over to law enforcement, but pretending to be authorities in determining guilt or innocence in a rape case, if if the criminal justice system, so often gets it wrong, as we've seen with men who are exonerated by DNA evidence 30 years later, if the criminal justice system gets it wrong so often, what makes school administrators think they can do any better, quite frankly? Universities have incredible advantages in these lawsuits. Money on top of money, including insurance. So some of the things that most people don't necessarily think about it initially is that if there's a settlement, schools don't really pay that settlement. It's actually the insurance company. They just pay the premium on that insurance policy. Time. University administrators can wait out the plaintiffs because the plaintiffs, their career is disrupted, and a lot of the time they can't get back on track until the resolution of the lawsuit. And schools know that, and so they can drag out the process. And attorneys, they have attorneys that are dedicated for this kind of thing. Many of the students don't have the money for an attorney, and so that's a huge factor as well. The appearance of legitimacy, though not necessarily the substance of legitimacy, through Department of Education, what is called Office of Civil Rights Guidance. That's the Dear Colleague letter. Some schools do refer to that, some courts do refer to that as something that should inform student conduct proceedings, and they give it too much weight, I think. Reputation and identity, and this goes both ways. The accused, the student who brings a lawsuit against their school often files in the name of John Doe. In order to do this, they have to file a motion to proceed pseudonymously or anonymously. And a lot of the time, the schools will contest that and say, hey, the plaintiff needs to proceed under his real name. Well, the plaintiff may not want to proceed under his real name. He may want to not have it incredibly public that he was accused of rape. And there are some cases in which if the plaintiff is forced to proceed under their real name, that they will then drop the lawsuit because of that, because they don't want their name public. As we've seen before, there's sometimes parallel criminal litigation, which some administrators can kind of game to the system. And then there's cultural momentum behind what the university is doing, as opposed to things like the rights of the accused. I'm going to skip over some of this and get to some of the good stuff. So some could say that these universities are ripe for reckoning, and I want to get to some of the good news in context, and that is that there have been roughly 70% of lawsuits filed against universities have seen some form of positive outcome. And I want to really clarify what that means, because what is a victory and what is not. For example, in most cases, more often than not, probably about 55% of cases, there's been a positive ruling for male students. And then in some cases, there is not a positive ruling for the male student, but then the male student still settles with the school. That settlement could be a benefit for the young man, but what does that do necessarily for the movement? Not so much, because the litigation movement really needs favorable rulings in order to continue to gain traction. I'm going to spend just probably about another 5 minutes or so talking about some of the appellate rulings. There's been some rulings by now that have made their way all the way to federal appellate courts. Some of these are listed here. A lot of these have to do with due process, in particular the right to cross-examine the accuser, especially in cases where the accuser doesn't even show up to the hearing. And if in many of these cases, it's just he said, she said. And when it's he said, she said, then there's a question of credibility. And if there's no physical evidence, then you really need to probe into, why did you, ask the accuser, why did you text, the accused student, a day after the supposed rape and say, oh, I had a great time last night, I can't wait to do it again. Why did you do that? You need to be able to ask those questions. And if schools don't allow, the male students to have someone ask those questions, and a lot of time it's not the male student asking the female students questions, it's asking through an intermediary like an advisor, or forwarding the questions to the panel for the panel to ask of of the complainant. And so, yeah, there's several of these are here. It's interesting, Dixon versus Keegan Ali, that's another California university case. This is a private university, but it's interesting in this ruling, the judge ruled that the due process protections for a private university under common law mirror the due process protections at a public university. So it's very interesting that the judge would rule that way in a private university, because when people think of constitutional protections like due process, they tend to think of public universities. That would be more applicable to public universities. And Doe versus Purdue University is, I'm going to finish up the talk of the appellate rulings here. This was an interesting case where it really shows in some sense the limits of the relief that can be granted by the courts. For example, in this case, the federal appellate court believed themselves, even stated in their ruling, that the hearing, the process the university used was a sham. The accuser was not present for the hearing. She was investigated by a feminist rape advocate, rape counselor, anti-rape advocate, and that person who headed up like a sexual violence resource center at the school, she wrote a summary of the accuser's words and presented that summary to the panel. 2 out of 3 members of the university panel had not even read the report. The accused student had not read the report, and he was provided the opportunity to read part of the report just a few minutes before the hearing. And in that hearing, he saw that the report had forged a confession that he had made, it's interesting. This is why you need to be able to read the evidence against you. Despite this, he was found guilty based on no physical evidence and expelled. And so the appellate court, when they were reviewing this, they were talking to the attorney for the university, and they were saying, this is ultimately came down to a credibility contest, in which the university not only did not even speak with Jane Doe, they didn't even read words that Jane Doe had written. They read the words as they were interpreted by this rape crisis counselor, effectively. So, what else do I have here? I'm going to skip over some of this and get to some more juicy stuff. A very recent development is that there have been class action lawsuits filed. 3 of them. These are in the last 45 days. The impact of this is very significant. If any of these are successful, someone made a great analogy. It's like recalling a line of cars because there's a defect. That can retroactively, basically recall the punishments of potentially hundreds of accused students. So there's 3 in play right now. So that's one of the benefits, is that it's retroactive. Another thing is that it's especially useful for poor plaintiffs and people who don't have a lot of money and can't bring a lot of these lawsuits. Also, these things tend to take quite a bit of time to get off the ground as well. So, and then there's some of you may have heard that Betsy DeVos, the current leader of the Department of Education, has proposed new regulations on these issues, and these regulations offer much greater protections for the accused, a higher standard of evidence. Cross-examination is no longer forbidden. And it provides accommodations to both the accused student and the accused student. It requires meaningful notice of the charges. It forbids conflict of interest among decision makers. It requires that schools maintain records for 3+ years, and also defines, I skipped the first bullet, it also defines harassment more narrowly, which some would say, and I would say, is the real definition of harassment. It has to be severe, pervasive, and objectively offensive, based upon the Davis versus Monroe Board of Education standard. Harassment is not that one thing that some guy did to annoy me that one time. It's not that. So it's a pattern of something that is so severe, pervasive, and objectively offensive that it effectively denies someone equal access to education. So yeah, a lot of our work is, again, keeping track of this, and a lot of our work is talking to potential plaintiffs and attorneys and reporters who wish to discuss these issues. If you want to check out more about it, feel free to look at our website, and TitleIX4all.com. And yeah, thanks so much for having me today. Appreciate it.
Okay, we went a little bit long there, but there is time for a couple of questions. We got about 5 minutes.
I have more of a comment.
Sure.
My name is Brian. I'm an adult student at Wittenberg University in Springfield, Ohio. This is so detailed and so accurate. I'm the only student at my school that has spoken out several times against the extreme feminists who then put me through this process. And this speaker's presentation is so accurate and so detailed, it literally might as well be at my school. I mean, I'm looking at this and it's just making me unbelievably angry just to even look at this, because you're literally talking about my school. They've said I've created a hostile environment and this, that, and the other. When I refer to their kangaroo court, which is what this is, when you're talking about the appeal process, that's also made up by the feminists. The people that give you the trial are the feminists. Our student code of conduct office is handled by 100% females, which are all extreme feminists. This is so accurate, and I'm living this right now, going through it right now multiple times. So his presentation is unbelievably accurate, and it really is, it's frightening, because you literally are depicting what goes on at my school. I just wanted to say that, but thank you.
Thank you. And best wishes.
My question is about process of regulation. Could you just briefly tell us where those OCR regulations from Betsy DeVos are, and what are the possibilities that they're actually going to become implemented? And then I have another question offline about change of administration and its potential impact on that process.
Yeah, sure. So the proposed regulations can be found on the Department of Education website. You can just, probably more easily just Google the proposed regulations. You can find them on our website too at TitleIX4all.com. The likelihood of them being instituted in some form, I would say is fairly high. My concern is that Betsy DeVos may have. The regulations are so extensive. They're far more extensive than anything we've seen before. My concern is that DeVos may have bitten off more than she can chew necessarily, because the broader the regulations are, the more time that'll take to get instituted. But nonetheless, I think that we'll see something instituted like that. But I think it'll be. I wouldn't be surprised if they decided to kind of pare down some of the regulations. So the real benefit is that this will give greater force to lawsuits against universities, and that'll just increase the ramp up of that litigation. So.
Hi, I'm curious what a student who has not been accused of anything can do to stay safe and protect himself, and if any universities are better than others as far as upholding due process and civil rights.
Some universities are definitely better than others. Some states are definitely better than others. California and New York and Massachusetts in particular are particularly bad states for the accused. What you can do is, I wouldn't advocate, being afraid to, talk with women or get together with women, but I would avoid parties where there's a heavy amount of alcohol consumed. Especially fraternity parties, because those are just, those are in the spotlight for administrators. So just, yeah.
Thank you.
Morning. I'm from the UK, and I've got a teenage son. And I've also seen in the press that Cambridge University, for instance, is looking to change its the evidence required in these kinds of cases. So I'm obviously concerned that we're heading down an earlier point in what America has been doing. I'm just wondering if there's any advice that you can give on how I can perhaps start raising concerns, and which area I could focus at to show these universities, look, if you go down this route, this is the potential consequence for you. One of the things that concerns me, there was an open letter in Cambridge University that was signed by 800 students that want this change, and it seems like it's like turkeys voting for Christmas.
Well, unfortunately, I think there's very little that can be done if they decide to go down that path. I think that really the best you can do is just continue to point out the inaccuracies behind they'll almost certainly state that there's an epidemic of rape on college campuses and things like that. Pointing out the deficiencies in those arguments is good. Pointing out the bias among those who advocate, greater intervention by universities is also good as well. But yeah, I mean, ultimately, yeah, it's a very difficult battle. So I wish I had a better answer for you. So, thanks.
How retroactive would retroactive be? I was summarily dismissed in 1977 from the California School of Professional Psychology.
Yeah, so I think the greater issue may be that with class action lawsuits, the plaintiffs have to be similarly situated plaintiffs. So that really addresses, I think, the core of your question. It really depends upon, I would think, I honestly don't know if they'll go back that far, but it depends upon the nature of the proceedings that were used against you.
There were none.
Yeah.
I don't even know who I supposedly harmed.
Yeah, like for example, the class action lawsuit against Michigan State University is based upon a ruling, a ruling that came out in 2018, and that hinges upon a lack of a hearing and a lack of cross-examination. So students who fit that situation may be similarly situated. Same thing with some California universities.
So would I have to join this suit?
Yeah, you would have to join the suit, and yeah. Okay. All right.
You better make it quick.
I was accused of sexual harassment, and this is like a direct quotation. He was manipulating my emotions and lying to me by telling me that he was not attracted to me. And I was sanctioned with counseling, like one-time counseling for this. But I'm actually one of the luckier ones. So the Boyermeister case actually happened at USC. So he was expelled from the school as a football player, even though the girlfriend actually denied that any violence happened, like multiple times. And I reviewed security footage, which should establish to any reasonable person that he was innocent, and he was still expelled. So,
Yeah, that's one messed up case. I agree. So.
All right. Shoot. Thank you. Everybody, Jonathan Taylor, amazing work. I do want to remind everybody, before I forget, because if I don't do it now.